Joining me now from Washington, D.C., President of Judicial Watch, Tom Fitton. Tom, so you are suing the state of California for this reckless and unconstitutional law. The White House is suing over this reckless and unconstitutional law that they passed. Is there going to be an effort to conjoin the cases as you travel down the legal path?
Yeah, I suspect they'll all be put before one judge out in California. We represent voters in California whose rights are being rolled over by this vendetta by California politicians against the president. They want to get his tax returns. The Constitution's not going to get in their way. And in their effort to get Trump, they're destroying and undermining the rights of voters in California who have a right to be able to vote for elected officials, or specifically primary presidential candidates on their primary ballots. And the idea that they be knocked off the primary ballot because California added an extra impediment beyond the constitutional requirements is just an affront to the rule of law. You know, Jerry Brown vetoed the prior version of this bill.
Right.
But Gavin Newsom is drinking the Kool-Aid, the anti-Trump Kool-Aid, and he's willing to break the Constitution and undermine our election system because they have it in for Trump. It's really it's a dangerous constitutional crisis we're in when we have states willing to go this far.
You know, and we say on the golf course, Tom, a good bet is reversible, right? Imagine if the state of Texas in 2015 was trying to do this to Hillary Clinton. Oh, hell would break loose in Washington, D.C., and the wagons would be circled. There's barely a ripple in the mainstream media. It's a footnote in the mainstream media this is going on. But what does the law say? Well, in part, the unconstitutional law, I should say, in California, what does it say? It says, in part, requires a candidate for president, in order to have the candidate's name placed on a primary election ballot, to file the candidate's income tax returns. Who do they think they're fooling here? I mean, you might as well substitute candidate for president with Donald Trump. I mean, this is an attack on the 45th president of the United States. That certainly has got to be part of your case.
Oh, exactly. And certainly the president's making that point. They're after him personally. But imagine if, let's say, Texas or Florida or Kentucky or someplace like that decided to say, hey, we want the medical records of candidates. We want the college records of candidates. We want the genetic testing of candidates targeting Elizabeth Warren. I mean, that's the craziness that California's unleashed if the courts don't step in and uphold the Constitution.
The Constitution is clear, Tom, and you and I know it. It's crystal clear on this issue. Article 2, Section 1, there are 3 requirements, effectively. You got to be a citizen, you have to be 35 years or older, and you have to be 14 years a resident in the United States. What California is trying to do is unilaterally rewrite the United States Constitution. But here's what worries me, Tom, because this is an Article 2 function. In reality, it doesn't involve the Article 1 branch and should not involve the Article 3 branch. And you have all these Obama judges out there, all these radical judges. I just worry that we put this before a judge where it doesn't belong. It doesn't belong in the Article 3 decision-making scheme, but yet here we are. So it's, you know, I mean, let's face it, it's risky business.
Right, and, but on the other hand, this is a pretty straightforward case, and when you have Jerry Brown on your side, who's a hardcore Democrat liberal activist who didn't want to sign on to this, and even sensible Democrats, and I'm sure there are some Democratic candidates who would object to this, maybe not the specific requirement, but the idea that the states can add additional requirements to those 3 narrow qualifications you laid out as described in the Constitution. You know, the question is, are we going to allow the Constitution to guide our system, or are we going to allow this anti-Trump fever to guide it? And too often it's this anti-Trumpism that's been running roughshod over the rule of law. And you're right, sometimes the judges catch that fever as well. But I think in this case, it's almost inevitable, nothing's a sure thing, that this requirement is turned aside. And it has to be done by November, by the way, because that's the time frame that the law lays out in order for the person to appear on the ballot, specifically President Trump.
Right, and that's a quick calendar. And this is being fueled by the radical attorney general in California, Javier Becerra. the radical governor, the radical leadership. Where are the good, rational people of California? And unfortunately, part of this equation is, Tom, they're not being taught the United States Constitution. They don't even know about Article 2, Section 1, and that's the real crux of the problem here. Tom, thank you.